My name is Amanda Dernovshek, and I'm an attorney here at Foster Swift and a member of our firm's Business and Tax Practice Group. Our first webinar in this series was held on April 9th, 2022. In that webinar, I reviewed the qualifications to become a women-owned small business and how to obtain the women-owned small business certification through the Small Business Administration. On June 7th, I spoke with attorney Mindy Johnson about executive compensation options and negotiation. Today is our third of 4 sessions that we have scheduled for this year. Each session will provide ample time for participants to engage with our attorneys, discuss legal opportunities, and problem-solve challenges that women leaders face. This session is being recorded, and we will email you a link following the program, along with an opportunity to reach out to our attorneys that we are speaking with today. We want to be respectful of your time, so we will limit this to 30 minutes. And today's program is informational only and is not legal advice. In today's discussion, attorneys Andrea Badalucco and Jackie Dupler will discuss how to protect your business assets and the importance of a prenuptial agreement. With that, Andrea and Jackie, welcome and thank you so much for your time today. Please introduce yourselves and we can get started.
Sure. I'm Andrea Badalucco, and I work in the Southfield office at Foster Swift, Collins & Smith, and I focus my practice in the area of family law.
I am Jackie Dupler. I am in the family law division here at Foster Swift, Collins & Smith in the Lansing office.
Great, thank you both. So I know the purpose of our session today is to really focus on prenuptial agreements, protecting your business assets, and really focusing from looking through a women's lens about these issues. So the first question I had for you is, how are business interests handled in a divorce?
So the first thing that I always ask clients is, do you have a prenuptial agreement when they're coming to me? Because that may give us some guidance on how well secured separate interests might be. And so what many of my clients who own the business, or in some instances where they are the non-owner spouse, what they want to know is, can I reach it, or can my spouse reach it, even if it was acquired prior to the marriage? That can often be guided. I'm not going to say answered. I'm going to say guided by whether a prenuptial agreement exists. So that's the first thing that we look at. Would you agree with that, Jackie?
I would. I think it's important to know if there is the guidepost, as you referenced, Andrea, of a prenuptial agreement. And I think if you don't mind, I'll kind of segue here and talk about what's marital property and what's not. I think that's important whether or not we have a prenuptial agreement. Marital property, to put it simply, is everything, whether we're talking assets or debts, acquired from the date a couple is married, all the way through the date their divorce is finalized. For example, property can include a business. It can include the debts that a business has, a home, the mortgage, vehicles, car loans, credit card debt, whether it was used to purchase furniture, gas, groceries. Generally speaking, it doesn't matter how that debt was acquired if it occurred during the marriage. So we need to figure out, if something is marital property or not. Separate property, generally speaking, is defined as property that's acquired prior to the marriage, so premarital property, which of course could be outlined in a prenuptial agreement, as well as items that you receive during a marriage through gift or inheritance. But to that end, for something to maintain its separate nature, so for the court to consider it separate property rather than marital property, you have to continue to treat that property as separate property. So for instance, if you have a bank account that you had since you were a child, and during the marriage, you just rolled that into joint finances, or if during the marriage, you chose to cash in some of those savings bonds you had as a child because it was tough to make the mortgage that month, then you might be actually commingling, making separate property now marital. So that can be an issue. Andrea, of course, if you have something to weigh in on that, I'd love to hear that as well.
Right. I was intrigued when you mentioned vehicles. I mean, that might seem like a small thing, but if your company owns the vehicle, and then who's driving that vehicle? Are you driving it? Is your spouse driving it? Are your children driving it? Who's driving it? Then is that going to be considered personal property of the marriage? Or is that going to be because de facto, meaning it just happens to be that in reality, this is what we do, as opposed to what the title says it is. So just because it's owned by the business, we as attorneys in family law are going to look at what, as a practical matter, are you using this item for? And the same rule essentially is going to apply not just to a vehicle, but to, yes, we've seen it, a boat. It applied to virtually any item of personal property that you may have within your home. Sometimes folks go on business trips, and certainly there may be a business aspect to that, but are you bringing along the whole family? And is it a way of life? Because this is then going to be something else that you would want to consider. Is the business, are you taking specific owner's draws for $10,000 for a trip to Cancun, or are you paying on the company credit card? So you have to be careful how you're going to use a company credit card, how you're going to accrue debt, as well as assets that are part of that business. So it's how separate can you keep it is really the question. And the cleaner your books are, the cleaner the transactions are, the better off you're going to be if you are trying to preserve this particular asset as being something that was not acquired during the marriage. There may be some value that can be attributed to the business during the course of the marriage, and maybe you can just limit it to that inquiry as opposed to putting in the entirety of the asset itself. So that's going to be what I'm looking at when I'm reviewing this particular problem with a client. And it's what we call a fact-intensive inquiry. So we do want to try to define and put into buckets, what is each thing? Is it separate? How do we know it's separate? Asking the pertinent questions. Is it joint? Is it something that is titled in both of your names? Well, then let's put it in that bucket. Are we going to be looking at something that might be a hybrid? How would it be a hybrid is the next question. So you might do well to get a prenuptial agreement, but that's not the end all be all. And that's really the point of this discussion today, is to just bear in mind as a word of caution that when you're setting up your business, there are going to be considerations that you'll want to make so that you don't run afoul right from the get-go of trying to preserve that asset from being considered as part of the marital estate.
Wow. So it sounds like this gets very complicated very quickly. And sometimes people may intend for certain assets to be outside of the marriage, but how they use that asset or treat that asset actually brings it into the marriage. Are there documents that can be drafted to protect those assets, or other steps that you can take to protect those interests and make sure that that asset is what you're intending for it to be?
Right. So we talked a little bit about prenuptial agreements without going into great detail about them. But there are also things like buy-sell agreements that you can get. So what is this stock going to be worth in this particular, even if it's a privately held company? That can clarify for us, what is its worth? What did we think its worth was at this time? And maybe the market hasn't impacted it in some way that wasn't anticipated at the time of executing that buy-sell agreement, but it gives us a place to start. So that might be something that you want to do, but again, you're going to want to be cautious about it because it's not going to be the only answer. So there are some people look into post-nuptial agreements. I'm not a fan. So I just want to let you know that those are out there. They do exist. The reason I'm not a fan is because there's a big question mark above any judge's head about whether it should be enforceable or not. And so going to the trouble of trying to draft such a document may not necessarily do you any favors, but a prenuptial agreement may, a buy-sell agreement may. Talking to someone who is savvy as a business lawyer or corporate lawyer makes a lot of sense to me. Prior to engaging in getting toward the prenuptial agreement even. To me, that might be an inquiry that you would want to make if that's a consideration in your set of circumstances. So what I like, frankly, about Foster Swift is that we have business lawyers, we have corporate lawyers, we have tax lawyers, and they are right down the hall. So it makes it really easy for us as practitioners. I know Jackie feels the same way. I saw her big smile. That we're able to go knock on someone's door and request some assistance on a particular item. But I don't want to put any words in Jackie's mouth. I'm sure she has something to say about that too.
No, I do agree with you, Andrea, and you're right. I did have a big smile because it is nice being at a firm where we have those resources, and attorneys, much like doctors, we specialize. Not many attorneys now are generalists and practice all areas of law. And so I think going to someone that, like Andrea said, is savvy and is experienced in the area of law pertinent to your exact issue, exact question, I think is really important. In terms of prenuptial agreements, I'll talk a little bit about a prenuptial agreement, even though we've already given, I don't know, 4 caveats, I think, to say that it's not necessarily foolproof. It's unfortunate, we need to stress that, but I don't want to give any of our viewers here false confidences or false ideas that, you know, if you have a really well done prenup, there will be no issues. So in terms of a prenuptial agreement, it is important to understand that a prenuptial agreement cannot address child-related issues. So even if you're, you know, on the cusp of getting married and you want to talk about who has custody or what's the parenting time if we have children years down the road and later on have a problem in our marriage, the court cannot enforce the terms of a prenuptial agreement about custody and parenting time. And the reason is because the court still has authority and jurisdiction to make those decisions based on the child or children's best interest. So you can't just have a contract done in advance that just outlines everything and then you have to follow it. That said, if you did try to include provisions like that in the prenuptial agreement, and in reviewing it, the court still believes that that's in the best interest of the children, then it's very possible the court will follow those provisions. But it's generally, most, I think, attorneys won't include child-related issues in a prenup, knowing that it is so ripe for litigation in the future. In terms of a prenuptial agreement, it's important, if there is one, that the prenuptial agreement is not created or agreed upon based on some sort of problematic circumstance like fraud. If you say in a prenuptial agreement that there was full disclosure of all assets and debts, but someone intentionally forgot to talk about their pot of gold, that's an issue, right? I mean, that's important information that maybe you would have made different decisions had you known that there was this pot of gold. You know, we don't see many pots of gold, but of course, I'm sure you understand what I'm talking about. In addition, if a prenuptial agreement is created or signed upon duress, and legal duress isn't just, I'm kind of stressed because I sent save the dates, and I'm going to be pretty embarrassed if we don't end up getting married. Duress is more than that. It's not necessarily as far as a gun to the head, but it's around that world. So it's, again, not just, you know, I've already sent out, I won't get my deposit back on the wedding venue. I already have the dress completely fitted. It's more than just a financial situation. Again, it could be if there's a misrepresentation. So like I said, with the pot of gold, if somebody intentionally doesn't tell you that they have $500,000 in business debt, no big deal. You know, that's an issue in a prenuptial agreement. And similarly, and I guess I'm kind of using examples that fit multiple, but non-disclosure of a material fact, that would be another issue in a prenuptial agreement. So it is best practice, if you are looking to have a prenuptial agreement, that you do make sure you talk to an attorney, that both parties talk to separate attorneys, or at least have the opportunity to do that, and that the documents in writing. But again, I would echo what Andrea said earlier, that it is important that you also consult some sort of business attorney to make sure that the way in which you're running your business and plan to run your business does not run afoul or create more problems if there is a prenuptial agreement down the road.
Right. So some of the questions that I get too are about family owned businesses, and let's say that it is over time that one person winds up over time being gifted stock or earning stock, or that they're even inheriting the business in its entirety. So just like with anything else, when something is gifted or inherited, like if you inherited this chair from your grandma, this chair would be yours. It's not considered marital property. So bearing that in mind, it may be important when you're looking at, okay, how am I receiving this interest? Is it gifted over time? Is it inherited? How can this be set up so that I minimize down the road someone claiming as my spouse that I've not even met yet, let's say, saying that this is my property. So, or joint property rather. So that is something to bear in mind. And also, you know, Jackie and I have both litigated prenuptial agreements, and that's why we do say that it is informative, though not completely dispositive. And I do want to also point out that it is the burden of the party claiming it as separate property to prove that. So you can't say it's mine, it's separate, and so there. Now the other side then has to respond and prove that in fact it should be considered marital. But that's why we as lawyers are asking these questions about, okay, well, you had these 5 vehicles, and they were titled in the business's name, but who used those vehicles, for instance? So that is where the burden and trying to prove what are you looking at, is it characterized more properly as being joint or marital? So another thing that we had talked about in preparation for today, Jackie and I, was what about the question of, now let's say that you've solidly proven that by no means is this particular business asset going to be considered marital. Okay, so how can the other side, the spouse on the other side, still get their hands on it? I mean, I thought that was a done deal. The answer is not so fast, because there's this concept of what, Jackie? Invasion, right? So regardless of whether there's a prenup, strict adherence to that business being considered not reachable that's not reality. So you can invade someone's separate property. But again, it's going to be a fact intensive inquiry, and they're going to be looking at the number of years that you were married, what the other person did to contribute to the business, how many children did you have together, who was the person who stayed at home the majority of time, et cetera, and we could go on. But so when you look at the invasion question, that is what winds up being litigated, at least in my experience, 9 times out of 10.
Wow. So it sounds like from what I'm hearing, I'm not familiar with family law like you all are. And I just think it's so fascinating about the use of the assets, and that you can go through you can jump through hoops, get an attorney, get a prenuptial agreement, and you think that you're all set. But then in reality, it could still be invaded, as you called it. So what happens if there's a prenuptial agreement and it meets all the criteria? And it's very clear about who owns what before the marriage, but the other spouse wants to invade that person's property. What does that look like? I mean, what factors does the court or does an attorney look at to determine if that's permitted?
To me, what I try to look at is how can we solve this problem? Because you're not going to get the answer unless you spend the resources down to go through a trial, because who can answer that? The trial judge. That's who. And so how can you reach an agreement short of having to expend those resources? And so one of the things I like to look at, and I bet Jackie does too, is try to figure out what stream of income is produced by the entity, what is reasonable then to consider as child support or spousal support, and carve out any argument or limit, to the best of our ability, any argument that the property itself, the corpus of the business, should be awarded to the other side.
I would agree with you, Andrea. I think the other thing, and of course with this entire presentation and series, meant for women business leaders. I think everyone can understand if you own a business, there are certain instances in which you're doing a cost benefit analysis, right? Is it worth it to spend to chase pennies with dollars? Obviously it's not. So if it's a situation where perhaps through resolution, mediation, negotiating through attorneys, is it a situation where maybe you might give up a little bit more than what you think should actually happen, but it's going to cost you a lot less financially and emotionally to come to a resolution? It might be a situation where it's worth it. I'm not saying that's what everybody wants to hear, but I don't like to, if there's a situation where we could get an extra $500, but I think looking at the facts, it's going to cost us $5,000. The principle's not worth it, right? So we want to make sure that we're being practical and fair, because these are families. And when you walk out of that trial, for instance, if you have children together, whether or not they're minors, you have to live with each other in one another's life. So we want to make sure that we're doing things in a practical way, as well as obviously what's best for our client. But there is a lot of cost benefit analysis that I think goes into that sort of inquiry and that sort of issue. Just want to make sure that that's a consideration for clients.
Right.
Yeah, absolutely. I think we always hear that phrase like they're litigating on principle, and that's expensive. And I think that's really what you're getting at, that sometimes as a business owner who's going through a divorce, you have to take a step back and say, what is this going to cost me, and what am I going to get out of this? And sometimes you just have to negotiate, like you said, and come to an agreement that's outside of what a court might do. But it saves you money and time at the end of the day. So I think all of our listeners will really resonate with what you were just saying, Jackie, and they'll understand kind of that give and take about making those choices. Andrea, you mentioned a couple of times having a business attorney involved with these types of issues. Can you tell me a little bit more about why you might want a business attorney and a family attorney involved with a divorce that, does have some business assets?
Sure. So one of the things that I notice when it's a privately held business is that there are going to be maybe not the cleanest books ever. And I know that we're ultimately going to wind up in front of a business valuation expert. I want to put my best foot forward. So in order to make sure that that best foot forward is going to the expert in document form, I like to confer with someone who understands businesses in a way that it will appear that we have the cleanest set of documents possible, and that any areas where there are some gaps can be explained in a reasonable way, so that there is not an imputation of income or phantom income or something that the other side is going to pretend is there. So let me back up for a second. I want a business valuation expert to explain two things to me. One, what do you think this business is worth, assuming that this is part of the marital estate? Two, what is the stream of income? And the stream of income is probably the more important of the two questions to me, because I'm going gangbusters to try to preserve that business as being separate property, right? Mm-hmm. So really the question that I'm going after is stream of income. If I have a business law-minded attorney on the case as well, it assists me in ensuring that the expert is going to find things to my client's favor. If I don't have that business law expert, then somebody chirping in the business valuation expert's ear about the cash under the table or the this or the that will become a more viable question for the expert to consider. But if I have a set of books, including personal accounts, if necessary, and I hand that package to my business valuation expert, it can explain away any concerns about the chirping.
Mm-hmm. Yeah, that makes total sense. I think all of this is really fascinating and super helpful to our listeners. Before we wrap up, did either of you have any last minute thoughts or anything that you wanted to mention before we are done today?
I would just echo a sentiment that I know we've said a couple different times and probably phrased it a few different ways, but the cleaner you have your business books, including how you're paid or how you take draws, how you pay your ongoing home expenses, your mortgage, those sorts of things, the better it is. Because Andrea said a couple different times that these sort of issues are very fact intensive, and it might seem in a divorce very invasive, but there are times where through the courts, we have to show many, many months or even years worth of personal and individual bank accounts that really track the money. And so the cleaner you have your transactions, the better it is to show that something is truly for the business or truly for the home. So that's something that is difficult in practice. I understand people live your lives, you're busy, but the cleaner it is, I think, especially if you work with a business attorney on the front end, I think that the better you can do for yourself.
So one of the things that business valuation experts look at is they look at the last 3 to 5 years worth of books and tax filings, et cetera. So that's a number you might want to keep in mind, 3 to 5 years in the past. And they also, of course, want to confer with the business owner to get an idea about what's the trajectory looking like for this company in the future. What makes it even more viable than it is today versus what are the pitfalls and problems that that particular business is facing. So I guess the only parting words that I would leave everyone with too is go ahead and look into the prenup. Go ahead and make sure that you are disclosing absolutely everything as Jackie described when executing that prenup. Perhaps execute additional documents after conferring with a business law attorney. And that just understand that if the marriage does end in a divorce, you're going to need an attorney who understands how to litigate prenups, likely, should you have one, and argue separate property. So this is something that Jackie and I are both comfortable doing, and we hope that you will consider Foster Swift and all of the resources available here when you are looking for some guidance.
Perfect. Thank you, Andrea, and thank you, Jackie, for your expertise and your willingness to discuss this topic with us today. I want to thank all of you that are attending this session of Legal Strategies for Women Leaders. And as mentioned, we will be sending you a link with the recording of today's discussion, as well as a short survey. We value your feedback, and we look forward to providing you with valuable programming. We have one more session that is scheduled for October 4th this year, and we will be talking about effective estate planning and planning giving opportunities. So it goes hand in hand with some of the things that we've talked about today. And as we wrap up, the screen should be showing a list of the firm's women attorneys and their areas of practice and contact information. This will also be included in the link if you have any question on today's topics or have any other questions at all. As women professionals, we really value the opportunity to network and to do business with other women leaders. Please consider this an open invitation to reach out to any of us on the webinar today or any of our women attorneys. And thank you so much. We look forward to seeing you in October.